Now, this is not something that's unique. In the Articles of Confederacy, this was a main point as well. Article 6 of the Articles of Confederation: no state, without the consent of the United States and Congress assembled, shall send any embassy to, or receive any embassy from, or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States, or any of them, accept any present, emolument, office, or title of any kind, whatever, from any king, prince, or foreign state, nor shall the United States and Congress assembled, or any of them, grant any title of nobility. Currently, there are also 2 other sections of our Constitution today that prohibit titles of nobility. Article 1, Section 9, limits on Congress. No state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold or silver coin a tender in payment of debts, which is something else that's totally for another time, as your money is made out of paper, pass any bill of attainder, ex post facto law, or law impairing the obligations of contracts, and at the very end here, or grant any title of nobility. We also have Article 1, Section 10, powers prohibited of states. No state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit. Wait, I'm sorry, I read the wrong one. Without humor, all of this is worth nothing anyway. There it is. I read them backwards. Article 1, Section 9. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. So essentially, this is already on the Constitution. The removal of the 13th Amendment was unlawful. It was lawfully ratified and lawfully passed. It is as if they were to stop printing the Second Amendment and then say you can't have guns anymore. The ceasing of printing a lawfully ratified amendment does not have the force of law to repeal that amendment. The only way to repeal an amendment is with another amendment, as we saw happen with the 18th and 21st Amendments. Prohibition was a very bad idea, and quickly the people realized that. So that power was repealed. That power was repealed in whole, which makes me question a lot of other things today government prohibits. I'll be touching on that a little bit more later. Before we can consider law, we have to consider every law in the scope of the Constitution. An unlawful law is not law. Any act of Congress, any act of a judge, any police officer, anything like that, any kind of act that is unconstitutional is unlawful. It is not law. It is void retroactively to the date it was passed, not merely to any kind of date of a decision branding a law as unconstitutional, but from the very outset. The Constitution is not something that needs to be interpreted. It says quite plainly exactly what it means. It's the interpretation of this Constitution that's the problem. There are many court decisions that uphold this. I'm going to read a couple of those as well. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona. The claim and exercise of a constitutional right cannot be converted into a crime. Miller versus United States. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Snare versus Collin. An unconstitutional act is not law. It confers no right. It imposes no duties, affords no protection, It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton versus Shelby County. And the general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely from the date of the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. 16th American Jurisprudence, 2nd edition. All laws which are repugnant to the Constitution are null and void. Finding that the statute conflicted with the federal Constitution, Marshall considered it the essential of judicial duty to follow the Constitution. He concluded that the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument, being the Constitution. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by any ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Now, specifically related to that right to travel I spoke about earlier, there are quite a few Supreme Court rulings that establish this. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Chicago Motor Coach versus Chicago, Laguerre versus Chicago, and Boone versus Clark. The right of the citizen to travel upon the public highways and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege which the city can prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Thompson versus Smith. I know Supreme Court rulings can be boring sometimes, but they are the law of the land, because they are based upon the supreme law of the land, the Constitution and the Declaration of Independence. These are the laws, not what you see written in the United States code books. The right of the citizen to travel upon the public highways and to transport his property, either by horse-drawn carriage or automobile, is not a privilege which the city can prohibit or permit at will, but a common right. And that was Thompson versus Smith. I already read that. Oops. Okay. And now we get to the problem where there is a perception that driving is always and only a licensed privilege. And the courts have ruled on this as well. For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways, either in whole or in part, as a place for private gain. The latter purpose, no person has a vested right to use the highways of the state, but as a privilege or a license which the legislature may grant or withhold at its discretion. State versus Johnson, Hadfield Supra, Cummins versus Holmes, Packard versus Banton. As I said, the Supreme Court has ruled on this already many times. Heretofore, the court has held, and we think correctly, that while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part as a place for private gain. Barney versus Board of Railroad Commissioners, Willis versus Buck. What is this right of the citizen which differs so radically and obviously from one who uses the highway as a place of business? Who better to enlighten us than Justice Tolman? of the Supreme Court of Washington State. In State v. City of Spokane Supra, the court also noted a very radical and obvious difference, but went on to explain just what the difference is. The former is the usual and ordinary right of the citizen, a common right to all, while the latter is special, unusual, and extraordinary. This distinction, elementary and fundamental in character, is recognized by all authorities. Again, that's State versus City of Spokane. The right of the citizen to travel upon the highways to transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former is usually the extraordinary right. The former is the usual and ordinary right of the citizen, a right common to all, while the latter is special, unusual, and extraordinary. Ex parte Dickey versus Davis. I could read a couple more Supreme Court rulings, but I think it's pretty clear by now that everyone in this country has a right to use the highways of the country to travel and transport their property, and that as long as you're not doing commerce on the roadways, you're not a business that's required to be licensed by anyone. You have that authority when you're born. Now to cover the notary public. I do believe that we have a notary public that is a part of our group here.
We do.
What's his name?
Mike. Yes, I'm sorry.
Mike Miracle?
Yeah.
Mike Miracle is a notary public, and everything that I'm about to say are things that he might know about because he's a notary public. But that's not always true. Notary publics themselves have been kept in the dark about their powers. A notary public is ranked by executive law here in New York above a justice of the Supreme Court. They are here to keep us out of conflict. A person uses a lawyer when they're in conflict. An individual uses a notary public to avoid conflict. In New York State, the notary public's powers are all given by New York Executive Law, Section 138. A notary public has the power to make use of any common law document. A common law notary cannot handle documents intended for use in civil law, but the notary public can handle those documents that are intended for common law procedures, such as discussion. Discussion is what you use to avoid conflict. Say I have a tree in my backyard, and it's a very tall tree, and I'm about to cut that tree down. The honorable thing to do would be to discuss it with my neighbor, in case there are any problems that come along. If I try to discuss it with my neighbor, but my neighbor's not willing to discuss it, all I have to do to remain in honor lawfully is notice my neighbor, to put them on notice of what I intend to do. And through this, if they then do not respond to my notices, I have stayed in honor by giving them my intentions to try to discuss the matter, to avoid conflict. Courts are all about conflict. One cannot get to court without having conflict created in some manner or another. This is why the Law Society thrives upon creating conflict. Conflict created in dishonor is most often the reason you are in trouble in court, not for why you were there to begin with. Conflict is undesirable. It's unnecessary, and it can always be avoided by using discussion. An individual in America can go throughout their entire life without ever having to see the inside of a courtroom, simply by making proper use of discussion in common law. Your rights are the highest laws. Your property rights are laws.